Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss the legal victories and challenges to your fundamental freedoms and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties, education, and legal defense organization. Join us now as we explain the latest legal issues all across this country. In the courtrooms of America, Liberty Counsel is winning the battle for your constitutional freedoms.
Who really has the power to govern in California? Well, with Proposition 8, the California Supreme Court has said the citizens do. Hi, I'm Shawn Akers, Vice President for Middle Eastern Affairs with Liberty Counsel, and joining me again in studio today is Ron Miller, the author of the book Sellout, Musing from Uncle Tom's Porch, and a very active political and social commentator. Thanks again for being with us, Ron.
Thank you.
Ron, one of the things that has hit the news recently that is very exciting and a blow for true citizen leadership is a ruling by the California Supreme Court that says, basically, that the citizens have the right to act when government won't. In particular, here's what happened there. A group of proponents of Proposition 8, which would make marriage in California defined as one man and one woman, had Proposition 8 successfully passed by the people of California, and that was obviously highly contested, and it was appealed. And at the appellate level, a single judge, Van Walker, who many called to recuse himself from hearing the case at all because he himself was involved in the homosexual lifestyle, and many saw him as having an interest in the outcome of the litigation, was responsible for overturning the will of the people with Proposition 8. Now, that battle then should have gone on to the Supreme Court, but the proper parties generally, Ron, to bring a suit like that are the Attorney General through the governor of the state. But in California, neither the governor nor the Attorney General has felt so inclined to represent the will of the people in the state of California, so they said they're just not going to defend it and let it die there. The people, the proponents of Proposition 8, went to the California Supreme Court, and the California Supreme Court has said that if your governor and your attorney general will not defend Proposition 8 as it should, that you, as the people of California, have the right to do so.
That's excellent. In fact, there's an interesting analogy between that and the Defense of Marriage Act, where the Attorney General and the President of the United States have refused to follow their responsibilities, their obligations to defend the law. So the House of the People, in this case the House of Representatives, is stepping up and doing that. And I think this is going to be a precedent for future cases like this, because we're going to increasingly find that the will of the people and what I would call the preferences of the powerful elite are going to come into conflict with one another. So this is a very positive development, and it will probably lead us to the Supreme Court to see where this is going to be decided.
You know, I love this ruling on a variety of levels, but one that really sticks out is a foundational one. It is the misunderstanding often in the United States is that our elected officials are sovereigns, that the governor of a state is the sovereign of the state, and the president of the United States is the sovereign of the United States. And in fact, that's not the way that either states or the United States are organized. The United States Constitution, the preamble to the Constitution, tells you very succinctly who the sovereign of the United States is. It doesn't say I, the President. It doesn't say we, the Congress. It most certainly does not say we, the judiciary. What it does say is we, the people. The people organized the United States. The people organized the individual states. And in California, at least, the California Supreme Court has recognized that ultimately the people are the sovereign, and that when political decisions are made that aren't governance decisions like this one, where the people aren't being represented, that they have the right to represent themselves. And that is exciting. Now, I will say that Proposition 8 provides you with just a plethora of examples of this. One, the proposition itself was a citizen-initiated proposition. It was citizen leadership from the beginning. And now, when the state pits itself against the people and says that we're not going to represent your interest, that we're going to roll over and we're going to allow the interest that we like better to win without the legal fight that you're entitled to, the Supreme Court of California has said that you have the ability to represent yourselves. I think that is a blow for liberty and a blow against the leftist, elitist ideology that government knows better than the people, and you'll take the government that we give you and like it.
You know, it's really interesting that in California, of all places, somebody put the referendum into their process of government. I know that a lot of governments out there fear the referendum process for that very reason, because they don't want to give people the opportunity to take charge of what it is that they own. And in the case of Proposition 8, it's very clear that the courts in this case are going to side with the people. That doesn't happen all the time, but in this case they have, and I think that there are a lot of folks who, back in the day when they first put the referendum process in place in California, they're probably kicking themselves now simply because they would rather retain power than give it to the people, but it's exactly what they've done.
You know, it's a mistake to think that the United States is direct democracy. The founders of the United States thought that that would be a mobocracy, that it would be just what's popular rather than what's prudent. So what we did was really came up with a model that does both. The format of elections, the format of recalls, and the format of propositions, referenda, are the ways that citizens can balance those people that are put into office. You know, elections are the ultimate. In something like this, I'll tell you, the governor of California is going to have to answer to the people of California at the next gubernatorial election, and he's got to stand on the fact that he would not represent the interest of a very large portion of the Californian citizens. He's going to have to answer for that politically. But in the meantime, what this common sense ruling does is say that we're not going to leave you, citizens of California, without a voice. We're not going to strangle you. It's not that the government is promoting one side or the other. It's just saying that we're not going to put a stranglehold on and force silence on half of you because your governor disagrees with you. It says that literally you're going to be able to be citizen leaders and govern yourselves. And that's a very American and Republican small r, not direct democracy, but a small r Republican idea that we have this balance with our elected representatives.
Well, the idea of a republic is clearly to allow the protection of our rights without the chaos that could result from direct democracy. It's the difference between the American Revolution and the French Revolution, and it's something that Alexis de Tocqueville was very mindful of when he came from France to America, and noted that that brought stability and a guarantee of the protection of the people's rights. And so I think it's a great ruling. I think that and frankly, even if the governor and attorney general had agreed to defend it, obviously they don't support it, and they would not have given it the best possible defense. So the people that are going to go forward with this, I think, are going to really give it the representation it deserves and give the people of California the representation they deserve.
You know, Ron, I think that's an excellent point. In many ways, this is a better ruling than otherwise for the people of California, because the last thing you want is a lackluster defense of something that you believe in. So in some ways, I'm glad that the ideological elitist left stuck to their guns on this one and took a very radical approach, with the governor literally saying, "I'm not going to defend the law of California," which is kind of it's an extreme position. But what it did in this particular case was give over an upper hand to liberty. Now, if you want to be more involved with establishing liberty in the United States and learning about how you can do more than just vote, then partner with us here at Liberty Counsel. You can always call and make a donation to this organization that is fighting daily for your liberties, you can reach us both on the web at lc.org, or you can call us at 1-800-671-1776. And when you do, be sure to ask about the book, Take Back America, by Matt Staver, our founder and chairman. Matt Staver is in many ways leading a fight against those that would take away what we know makes America what it is. You can partner with him by joining with us here. So again, contact us at your convenience at lc.org or 1-800-671-1776.
You have been listening to Faith and Freedom with Liberty Counsel. We hope that we have motivated you to stand up for your faith, family, and freedoms. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email updates. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.